Welcome back to Dear Jane. I am Scott Baker. She is Marcy Little. Marcy, how are you today?
I'm doing great. So excited. Today's conversation.
Yeah, we're going to find out today how the Constitution does, in fact, protect the unborn. We're going to kind of get into the weeds a little bit and sort of push back against the argument that it does not. But before we do that, let's talk about our sponsor, our friends at Choose Life Marketing.
If you are a pro-life organization of any size, shape, or kind, or the needs of women facing unplanned pregnancies, if you are advocating for the rights of the unborn in the womb, you need to talk with our friends at Choose Life Marketing. They do a phenomenal job of helping you connect with the people that your organization seeks to impact. They also have a phenomenal fundraising department. So if you think, I don't know the first thing about marketing, and I don't know how we would pay for it, even if I wanted to do marketing. Our friends over there can help. So check them out, chooselifemarketing.com. They have a phenomenal team of pro-life strategists and specialists. That is their passion, marketing for pro-life organizations. So if that's you, go ahead and check them out.
So, Marcy, do you believe in unicorns running on a rainbow?
Do I believe in that a reality? No. Don't tell my niece.
What do you think is more possible, a unicorn running on a rainbow or a pro-life graduate of Harvard?
Oh, that's tough. Are there pro-life people at Harvard?
Well, apparently there is. Josh Craddock joins us today. He is not only is he a pro-life graduate of Harvard, he's also pretty decorated in some of the accomplishments he makes and some of the things he's done. He's an affiliated scholar with the James Wilson Institute on Natural Rights and the American Founding. He's been published in all kinds of different things, Washington Post, Newsweek, National Review. But yes, shockingly, he somehow made it through Harvard and is still pro-life. How in the world did that happen, Josh?
Well, Scott and Marcy, thanks for having me on the show today. Scott, you might be surprised. There were actually a good critical mass of pro-life law students at Harvard Law School, and I helped co-found the Harvard Law Students for Life chapter, and we had good attendance, good membership. So there is hope, even at a place like Harvard Law School. There are pro-lifers active and engaging in the fight.
So one of the things you specialize in is looking at the U.S. Constitution, and you have looked really closely at how the Constitution expressly protects the unborn. Sort of help us start to get an understanding of that.
Sure. Well, so about a century and a half ago, we fought a civil war, and we actually amended the Constitution to ensure that the Constitution's protections would extend to any person, so that they would be guaranteed the equal protection of the laws. Right after the Civil War, that was extremely important. And the drafters of that 14th Amendment to our Constitution, they were very careful. They didn't just want it to apply to that particular circumstance, but looking into the future, they wanted to ensure that no disfavored minority group would be denied the equal protection of the laws. And so they deliberately used this broad term person. Any person is entitled to due process and equal protection. And so when you actually, the Constitution, the 14th Amendment doesn't define that term person, but when we look back in the 1860s, what they meant when they used that term, whether it was in common or legal usage, it was very clear that that term person included the unborn child at any stage of existence. And so today, when we look at that text, the 14th Amendment, we try to understand what it originally meant and how it applies to us today. It's very clear that that term person, guaranteeing equal protection of the laws to any person within the United States, that includes the equal protection of laws to the unborn child. And so that effectively means that state laws allowing abortion are unconstitutional because those state laws deny equal protection on the basis of whether a human being has been born or not.
I want to get back to state law issue because I think that's fascinating, and I'm always thinking about, okay, how do we get these states in line, especially Josh, you and I are both in Colorado, just talking about that before we started this episode, and things are not great here. But I want to get back to the personhood point that you made, because that trips up a lot of people today. They get caught in these debates about, okay, well, maybe like the other side will concede, sure, maybe life begins at conception, but when does personhood begin? And I think that can trip up pro-life people. But it sounds like what you're saying is this amendment understood personhood to mean a specific thing contextually at the time that it was written. So I wonder if that is a helpful way to redirect that conversation about when does personhood begin. I don't know. What are your thoughts on that?
Yeah, a lot of times when people try and draw a distinction between a human being and a person, they're using a philosophical concept, and I find that a little bit uncomfortable, because when you look back in history, anytime that a group of human beings were declared non-persons, that usually was a permission slip to abuse, kill, harm, cause genocide toward that group of people. And so that makes me really uncomfortable. So I think that it is helpful in the legal sense. The focus of my research has been in this legal sense of the word person rather than the philosophical sense. And what we find when we look at that legal sense is that going back for 150 years, basically all the way up until Roe v. Wade, the unborn child was considered a legal person, and there wasn't a distinction between biological humanity and legal personhood. So anytime that the law, going back to Blackstone, for example, William Blackstone was this famous treatise writer who pretty much every American founder, if they were a lawyer, they certainly would have had a copy of Blackstone's commentaries on their shelf. And Blackstone's commentaries, he begins with a book called The Rights of Persons. And if you can believe it, Blackstone actually begins his discussion of the rights of persons with a discussion of the unborn child's right to life and personal security. Wow. So going way back into the English common law that the United States inherited on its independence, leading all the way up to the time of the 14th Amendment's adoption, and then even after that, up until Roe v. Wade, it was the consistent rule was that the unborn child was considered a legal person, and there wasn't this artificial distinction between biological humanity and legal personhood. Every human being was a natural person.
Does it, to understand the 14th Amendment, does it help to understand the context in which it was written, when, the historical time, all of that? Can help us sort of understand that period and when it was actually put together and what the intent was?
Yeah, that's a great question. So lawyers, a lot of times when we're trying to figure out what a law or a constitutional text means, one of the most common approaches to interpretation is something you might have heard of called originalism, or an originalist approach to legal interpretation. And this is very similar to the approach that the court took in the Dobbs decision when they looked at historically, did the 14th Amendment contain a right to abortion? And so they looked back at the time of the 14th Amendment's adoption, back to 1868, and they did a survey of all the state laws, and they looked at the state constitutions, and they found that actually abortion had been prohibited in pretty much every single state at the time of the amendment's adoption. And one of the things that I've looked at in my research is that actually when you look at those statutes, they're frequently classified, those prohibitions against abortion are frequently classified within the statutory framework of offenses against the person, right? You might have offenses against property, right? And then you have offenses against the person, like homicide. And that's where these anti-abortion statutes were housed. You also have statutes that specifically refer to the unborn child as an infant or a child. There was actually an Ohio state legislative enactment that came right after the 14th Amendment's adoption. And some of the same senators who had voted for ratification of the 14th Amendment, they sat on a committee reviewing this new anti-abortion statute that codified the common law's prohibition against abortion. And in their report, they actually called abortion, quote, nothing less than child murder. So really strong language coming from the 1800s. And so again, that's the historical approach. Why we look to history as we try and figure out, well, what did the people mean when they enacted this law? What did they mean by this language? And because the term person isn't itself defined by the Constitution, that's why we look to those indicators of historical meaning. So we might look to dictionaries of common and legal usage. And then when you look to those dictionaries, again, there's no distinction between human life and legal personhood. So you might look at Noah Webster's Dictionary of the English Language in 1864. He defined the term person as relating, quote, especially to a living human being, a man, woman, or child. And the entry for human includes all those belonging to, quote, the race of man, right? So that's one place that we might look. Another place we might look is the common law and the statutory history regarding abortion. And so I already kind of recounted some of that information for you with William Blackstone's discussion in his commentaries. You also can look back in common law and see that the unborn child was considered a person whenever it would be to his or her benefit. So based on authorities like Blackstone, as well as landmark English cases, state high courts in the United States leading up to 1868 declared, in the words of Massachusetts Justice Shaw, that the unborn human being throughout pregnancy, quote, is a person, and hence under civil and common law, to all intents and purposes, a child as much as if born. So that's another evidence, right? We might look at those court cases or the statutes that I was just discussing. That's another piece of evidence of what person meant at the time. And then, Scott, you mentioned what were the intentions of the people who drafted it, right? And it's pretty clear that they didn't have a specific intent to address abortion, right? There's no evidence of that, but they did have an intent to ensure that their legislative enactment would apply to future situations. And then the language they used, they were very clear that they wanted it to include all human beings. So the primary framer of the amendment, Representative John Bingham, he said that the 14th Amendment would prevent states from refusing, quote, any of the rights that pertain to common humanity. Or Jacob Howard, he was the sponsor of the amendment in the Senate. He said that the amendment guaranteed even the lowest and most despised members of the human race the equal protection of the laws. So it's very clear that the drafters of the amendment carefully crafted the text to include all human beings within the jurisdictional reach of the Constitution, regardless of their origin or circumstance. And I think that widely shared belief sheds light on the amendment's original meaning at the time of its adoption and what person was intended to mean.
So it's court. It's very compelling case you've laid out there. Would it take the Supreme Court ruling on something like this to clarify that, yes, the 14th Amendment, dead and born? Does that look like, somebody filing a lawsuit against one of these states that has decriminalized an abortion, taking that up to the Supreme Court? How do we on this as a way to start protecting unborn babies?
So that's a great question. So I actually think that every branch and level of government has a role to play. So we've already seen states after Dobbs prohibiting abortion, which is amazing. And that's their primary duty, right? The states still have the primary duty to protect life. But thinking more about, how we could get this to, like our state, Marcy, Colorado, we have a radical abortion policy of abortion through all 9 months of pregnancy. So what would it look like to ensure that the 14th Amendment is protected and guaranteed here for unborn children? And I think that there is where the federal government could actually play a role. So the primary enforcer of the 14th Amendment was actually designed to be Congress. So Section 5 of the 14th Amendment gives to Congress an enumerated power to, quote, enforce by appropriate legislation the Constitution's protections for persons, so equal protection. So Congress can actually pass a statute. They have an enumerated power to pass a statute, like, for example, the Life at Conception Act, to prohibit abortion in the states that are currently allowing it. Secondly, you mentioned the Supreme Court, right? The judiciary also has an obligation to enforce the law when a case or controversy comes up. So how would a case come up addressing this issue? Well, you might see it, you've probably been following some of the cases where the abortion activists have been trying to seek a state constitutional right to abortion. So there was litigation about that in Florida, for example. Well, one of the ways that this 14th Amendment argument could come up is if a state defends on the grounds that not only does its state constitution not guarantee a right to abortion, but also even if it did, the 14th Amendment, which according to Article 6 of our U.S. Constitution is supreme over state enactments and constitutions, even if their state constitution guaranteed a right to abortion, which it doesn't, the 14th Amendment's guarantee of equal protection would trump that. And so that's a way it could come up. And so that's a way it could go to the Supreme Court as well. And then finally, we might look to see the next pro-life president issue an executive order asking the departments and agencies within the executive branch to follow this interpretation of the 14th Amendment, right? So the next pro-life president could direct the Department of Health and Human Services, for example, not to allow the shipment and sale of abortion drugs, right? They could ask the different various agencies and departments to ensure that this understanding of personhood is adopted. And that kind of follows the example of President Lincoln, too, who did this exact same thing after Dred Scott, right? President Lincoln, Dred Scott had said that Black Americans could not be citizens. Well, President Lincoln, within his departmental authority, instructed the executive branch to issue patents to Black Americans and passports to Black Americans, even though that could only be done if Black Americans were citizens. So that's well within the executive branch's authority to do. And so we could ask for the next pro-life president to do just that.
So we talk a lot about what we're primarily talking about now are the rights of the baby. The other side is going to, and they always talk about the rights of the woman. So where do those rights play in the whole mix here?
Yeah, well, women are obviously entitled to the equal protection of the laws as well. And as the Dobbs opinion so eloquently points out, prohibitions against abortion don't deny the equal protection of the laws to women. And so, obviously we have to be, for an example, there's a case at the Supreme Court right now about emergency, life of the mother sort of exceptions for abortion. And one of the things that pro-life advocates have explained to the Supreme Court is that in those situations, both the mother and the child have a right to life. They're both patients and entitled to treatment. And so there's no, recognizing the rights and the constitutional rights of the unborn child doesn't in any way detract or oppose the equal protection rights of the mother and of women.
Is there any argument to be made about the right to health care or anything like that? Is there any counter to the whole 14th Amendment? Because that's what they say, right? That's where they come back, there's some sort of a right to, I don't know, the health care coverage or anything like that. Is there any kind of counter to what we're saying about the 14th Amendment here?
I don't think that's necessarily the direction that the counter would come from. Although I do take your point. I think that, obviously abortion is not healthcare. So correcting that misunderstanding is important at the outset. But, I don't think, again, this case at the Supreme Court addressing, emergency room treatment for mothers, I think is very, the statute that deals with that is very clear that both the mother and the child are patients and deserve, stabilizing care. And so, the right to, I don't see any inconsistency with guaranteeing equal rights to healthcare in that context, for example, and recognizing the right to life of the unborn child as well.
It's interesting because didn't the right to privacy that they found in Roe, didn't they to the 14th Amendment? That's interesting that it's, they're pulling opposing arguments from the same amendment. And I don't recall what the Dobbs ruling said. I mean, obviously they said, no, it's not there, but I don't recall the specific. You were just about the 14th Amendment. I just thought that's interesting that both of those came from that.
That's exactly right. Yeah, it's actually quite perverse that this amendment that was designed to ensure equal protection and due process for any person was then distorted to guarantee this purported right to abortion. So the Supreme Court in 1973 in Roe, what they did is they said that the due process clause has emanation. They extended some prior decisions that said that there's a right to privacy in the Constitution based on shadows cast by various amendments. And they said that that right to privacy extended not only to some of those prior cases, but also to this new context of abortion. And so not only is there no, explicit right to privacy in the 14th Amendment, but even it is a complete extension and fabrication of constitutional law to say that this extended to abortion. And so then in the Casey versus Planned Parenthood case in 1992, the conceptual or doctrinal basis for the purported right to abortion was kind of reformulated to be about the liberty guaranteed by the Due Process Clause. So the Due Process Clause says that no state shall deprive any person of life, liberty, or property without due process of law. And the court said that that word liberty has this substantive component that guaranteed a right to abortion, a fundamental right to abortion. And again, that was, as the Dobbs opinion points out, a fabrication from whole cloth, because there was no historical basis for claiming that abortion was a liberty guaranteed by the Constitution. In fact, again, it had been prohibited by nearly every state, and both at common law and by statute at all stages. And so Dobbs really corrected that constitutional error, and I think fixed one of the wrongful holdings of Roe, which was that there is this guaranteed right to abortion. Now, what Dobbs didn't do is it didn't go back and expressly overturn, or it didn't expressly fix the other error of Roe. Because to reach that conclusion that there is a constitutional right to abortion, Roe first held that the unborn child is not a person within the meaning of the 14th Amendment. So specifically, Justice Blackmun, he has this famous admission in which he said that if the personhood of the unborn child was recognized, then of course the case for abortion collapses, for the fetus's right to life would be guaranteed by that amendment. And so even Justice Blackmun recognized that if the unborn child is a person, then the 14th Amendment's guarantee of equal protection would apply to that child as well, and there would be no right to abortion. Now, of course, the court in Dobbs wasn't presented with this personhood question, and there's a doctrinal rule where the Supreme Court doesn't address questions that aren't raised by the parties. And in fact, they didn't need to address that question to decide the precise question at issue, which is whether Mississippi's law prohibiting most abortions prior to viability was unconstitutional. They could say, no, that's not unconstitutional, without going further to say, actually, that's also constitutionally required, right? They left that for future cases. But I think it's important to note that in the Dobbs decision, 5 times the majority opinion drew a distinction between those other what we call substantive due process cases, those other cases that found substantive rights within the due process clause. 5 times the majority drew a distinction between those cases and abortion, because they said that abortion is a unique act that takes the life of an unborn child. And so what the statute before us calls an unborn child. So if that distinction is correct, then I think that they're setting up the next set of, the logical next step, which would be to recognize that child as a person, just like every other human being.
So then the only hurdle for a national abortion ban is political and not constitutional.
Yeah, that's right. There are political pressures on Congress, obviously, political pressures on the justices themselves. I mean, recall that Dobbs was somewhat unprecedented in the way that there are political pressures on the justices. I mean, there was an attempted assassination attempt against Justice Kavanaugh to prevent this opinion from being decided. And so I think that you're exactly right to characterize the barrier not as a legal barrier, but as a political barrier. And so as we move forward in the cause for life, I think that, we're building a movement to recognize the constitutional personhood of an unborn child. This is going to be the next goal. For 50 years, we are working to overturn Roe v. Wade. Now our goal is to seek equal protection for unborn persons. And that's going to take a political as well as a legal approach.
Looks like we have Marcy is having connection issues again, so we will forge ahead without her. So if the challenge is political and not constitutional, what then can be done? Because if you think about if you believe the polls and things of that nature, it seems like the fight is lost, or at least is certainly an uphill battle. And anytime like a national abortion ban is discussed, it seems like it's DOA. What can the average person do? What action steps would you encourage pro-life people to take to maybe see this become a reality?
Well, I think, I try to stay optimistic about this because I remember that, back in the 1850s, it's estimated that less than 5% of white Americans were slavery abolitionists. And many of those were women who were unable to vote. And yet, by 1866, slavery was abolished, right? Another example, you think about how social movements have happened in the last few decades. You can think of, the 32 states passed, defense of marriage amendments, but there was a social movement on the other side and litigation that changed public opinion. And so I think that there are lots of examples in American history where public opinion can move on an issue rapidly. And so I think that, we shouldn't get discouraged because that is possible. And our job is to go out and try and advocate and convince our pro-abortion or pro-choice neighbors. And so making the case for life, explaining the humanity of the unborn child, and continuing, whether it's through digital media, on social media, or in person, continuing to try and convince and change hearts and minds is, I think, very important. And obviously that might be a slow process. It doesn't take necessarily winning in a California or Colorado right away, but it does take, working both on the political side as well as the cultural side to change hearts and minds.
JoshCraddock.com is the website. He's got all kinds of great content on there. Some pieces he's written, some videos, other podcasts, things like that. I would encourage you to check it out. Some really thought-provoking stuff, especially if you want to dig into sort of the legal side and in depth and that kind of thing. Josh Craddock, CRADDOCK.com. Josh, really do appreciate you joining us here today.
Scott, Marcy, thanks so much for having me on.
Thanks for listening to Dear Jane. Don't forget to subscribe. Of course, you can find us on all your podcast platforms of choice. Don't forget to follow us on X and Instagram. On behalf of Marcy Little, I'm Scott Baker. Thanks for listening.